V. Zalameda, Justice Mario V. Lopez, Justice Edgardo L. de los Santos, Justice Samuel H. Garland, Justice Ricardo R. Rosario, and Justice Joseph Y. Lopez. Court Administrator Jose Maidas P. Marquez, and of course, the members of the Justice Beat, particularly the members of Justice and Court Reporters Association, JUCRA, and the Justice Reporters Organization, or JUROR. On the occasion of the 120th anniversary of the Supreme Court of the Philippines, the Supreme Court Public Information Office welcomes all of you to SC in Focus, towards a technology-driven judiciary. Thank you for joining us this morning, and I would like to introduce to you our 27th Chief Justice, Chief Justice Alexander G. Gesmundo, who will deliver his message for the first time before the Justice Beat and the media. Thank you.
Good morning, my dear colleagues, headed by Senior Associate Justice Estela Perlas Bernabe, members of the Justice and Court Reporters Association, and Justice Reporters Organization, officials and employees of the judiciary, ladies and gentlemen. I am pleased to speak before you today. My first chance to do so since my appointment as Chief Justice. This allows me the opportunity to meet you, the partners of the judiciary from the media, to personally thank you for your hard work in covering the Justice Beat. I hope that this initial interaction of ours bodes well for our future communications. I find this occasion providential, for today marks the 120th year since the Philippine Commission, through Act Number 136, established the Supreme Court of the Philippines. The theme for this year's anniversary is Korte Suprema, naglilingkod ng may kakayahan, integridad, katapatan at kalayaan. Although the words competence, integrity, probity, and independence are used in our Constitution to describe the traits of a member of the judiciary, I believe that those traits should equally apply to the judiciary as a whole: justices, judges, court officials, and court personnel. The most valuable resource of any organization is its human resources, as its success is largely dependent on the people who composed it. The judiciary is no exception. The value of the court's workforce cannot be emphasized. Given the standard of training, expertise, and years of experience, our judges, court lawyers, and court personnel, it is imperative for the Supreme Court to exert every effort to secure the collective well-being of its personnel, especially during the global health crisis. I mention this now, following concerns raised by members of the legal profession of a looming judicial crisis pertaining to the fears raised by many that the judiciary would soon be hounded by the rising number of judges, prosecutors, public defenders, and court employees contracting the virus that causes COVID-19. Data from the court COVID response team shows that as of June 3, 2021, a total of 1,994 employees of the Supreme Court, the Court of Appeals, the Sandigan Bayan, the Court of Tax Appeal, and the trial courts have been afflicted with COVID-19 since the pandemic began. Of these 1,994 cases, there have been 1,846 recoveries, 33 deaths, and 115 active cases. The said data also reveal that out of the 1,584 court workers who underwent quarantine after contracting the disease, 213 were hospitalized, 33 were quarantined in COVID-19 facilities, and 972 underwent home quarantine or isolation. This is why, since my appointment as Chief Justice on April 5, 2021, the court has issued a number of administrative orders that were mostly related to health and safety concerns of the employees, court users, and lawyers due to the COVID-19 pandemic. The Supreme Court wanted to ensure that the judiciary will continue to administer justice without sacrificing the health and safety of its personnel. Foremost of these issuances is the inclusion of court workers in priority Group A4 of the Philippine National Deployment and Vaccination Plan for COVID-19 vaccines by the National Task Force COVID-19, which was made possible through the tireless efforts of Senior Associate Justice Estela Perlas Bernabé, then Acting Chief Justice. In addition, the court has issued guidelines for the extension of financial assistance to judges and court employees who unfortunately required hospitalization due to COVID infection. The court has also established an emergency care unit at its compound here in Manila and at the De La Salle College of St. Benil that serves as isolation and quarantine facilities for employees of the High Court and lower courts afflicted with COVID-19. Thank you, Justice Bedkagiwa, for making this possible. The Supreme Court likewise did its best to lessen physical exposure of our court employees and court users by adopting different work schemes and laying down the parameters for alternative work arrangement in our courthouses, which significantly reduce the risk of transmitting and acquiring the dreaded disease. We also granted requests of our judges and court personnel to allow the conduct of fully remote video conferencing hearings, regardless of the physical location in the country. As of June 4, 2021, there have been a total of 327,991 video conferencing hearings successfully conducted in our courts nationwide, or a success rate of 87.57. 303,189 of which are criminal cases, 20,000 of which are civil cases, and the remaining 3,777 cases of being an unspecified nature. We have also released 90,040 qualified persons deprived of liberties, or PDLs, and 1,217 of which are children in conflict with the law. It goes without saying that as Chief Justice, one of my short-term goals, not just for the High Court, but for the entire judiciary, is the immediate vaccination against COVID-19 of all court officials and personnel. This pandemic has lingered long enough and has had drastic effects, not just on the conduct of court processes, but more importantly, on the health and well-being of judiciary workers. With the High Court taking an active part in supporting the vaccination of its employees, the judiciary can play a crucial role in coping with and ultimately ending this pandemic. I am hopeful that with the inclusion of court workers in the A4 priority group category for essential workers, the majority of our court personnel will be vaccinated at the soonest possible time. With respect to adjudication, it cannot be denied that one challenge that has perennially confronted the judiciary is the problem of delay in the disposition of cases and in finding creative solutions to address the public's lack of access to responsive justice. These extensive delays in resolving cases have always had an adverse effect on the public's perception on our courts and the court processes. This is precisely the reason why among my short-term goals for the Philippine courts, like other Chief Justices before me, is the speedy disposition of cases. Favorably, my predecessors The Honorable Retired Chief Justices have spearheaded various procedural reforms that were crafted to ultimately improve the adjudicative processes of our courts. I do intend, with the support of my colleagues, to continue and move forward building on these reforms. Just last month, the Supreme Court issued 4 more procedural rules formulated to address the gaps in the procedure relating to recognition of foreign judgment on support, on procedures relating to anti-money laundering cases, and as regards the increase of fines to be imposed on erring judges. As far as the Supreme Court is concerned, what else can be done apart from implementing these procedural rules? During my term, I intend to focus on 2 things: case decongestion, that is the substantial reduction of dockets of the Supreme Court, and a technology-driven judiciary. We in the Supreme Court have taken it upon ourselves to amend our rules and commit ourselves to make our processes and practices more responsive, more efficient, and more attuned to the needs of court users. In line with this, the High Court has issued a resolution approving a number of amendments to the internal rules of the Supreme Court that are specifically meant to address the concerns of docket congestion. Foremost of these revisions are the following. 1. Changing the total period of continuances in the deliberation of cases in the Supreme Court. 2. Prescribing a period of 1 month within which members of the court shall submit reflections, comments, or suggestions, and a period of 2 weeks to resolve the case thereafter. Number 3, shortening the period for distribution to other members of the court of the member in charge report on a case prior to its scheduled agenda to at least 3 working days prior to the scheduled agenda date. Number 4, imposing a limit on the nature of administrative cases that can be elevated to the court en banc. 1. Only cases where the imposable penalty is suspension for more than 2 years or a fine in the total amount not exceeding 100,000 pesos. 2. In cases involving the lifting of judges or lawyers' suspension, only to those cases where the imposed periods of suspension are more than 2 years. Moreover, there has already been an effort among the judicative offices of the Supreme Court to hire more law clerks for the offices of the justices to help eliminate the substantial number of aging cases or those that are already beyond the 24-month constitutional period for deciding cases. Likewise, my fellow justices and I have resolved decide all petitions, cases, or matters that have been filed before the Supreme Court after April 5, 2021, strictly within the said 24-month period from the date of submission pursuant to Section 15, Paragraph 1, Article 8 of the 1987 Constitution, and to strictly observe requirements for the proper exercise of its judicial review. Additional proposals to increase the efficiency of courts are likewise being considered in coordination with the Rules Committee of the Court. There are plans to complete the revisions of the entire Rules of Court by amending the Rules on Criminal Procedure, which have been last amended in 2000, and the Rules on Special Proceedings. Additionally, as Chief Justice, again with the support of my colleagues, I intend to take advantage of the best technology available to make case disposition faster and continuous. The initial steps in improving and innovating our courts are the expeditious creation and strengthening of the ICT infrastructure of the entire judiciary, and the conduct of a comprehensive review of court operations and processes. This immediate review will give the Supreme Court a proper view of the administrative issues that needs to be addressed, particularly those that affect the operations of the trial courts. Times are quickly changing, and the judiciary must likewise adapt to these changes and transform its ways to be more responsive and effective in addressing the changing demands of our society. For this year's bar exam, aside from being automated, the court will likewise allow online submissions of bar examination applications and the electronic payment of bar fees. The judiciary e-payment solution will soon allow litigants to directly pay court fees online using various modes and channels of payments such as credit card, online banking, digital wallet, among others. There are also immediate plans to have a dialogue with the members of the bench and the bar to address specific issues that currently affect the legal profession and to coordinate with the Legal Education Board and the Philippine Association of Law Schools through the Philippine Judicial Academy to develop training programs related to judicial track and court management. This is in line with my view that the administration of justice will be better met if we have the support of all stakeholders of the justice system. Every stakeholder, justices and judges, court officials, the prosecution, private practitioners, and public defenders should be made partners of the court to ensure competence and efficiency in our judicial system. On the other hand, the long-term goals under my term will focus on the eventual establishment of the aforementioned ICT infrastructure that would have the following outputs. First, the establishment of an e-court system which will provide a unified, comprehensive, and intelligent case management system for the entire judiciary. An e-court system is envisioned to cover the functions of online payment or e-payment, online filing or e-filing, online wrapping of cases or e-raffle, and the maintenance of digitalized rolio or records of cases, to name a few. A short video presentation to give you a glimpse on this will be posted on the screen.
Want to be able to file cases online or pay court fees through mobile banking? Well, worry no more. All this is made possible through the eCourt version 2. What is eCourt version 2? The eCourt version 2 is one of the judicial reform initiatives of the Supreme Court of the Philippines. It aims to utilize technology as an enabler for swift and efficient dispensation of justice. Through technological innovations, it will enhance court workflow processes and mechanisms, institute efficient data management, and increase virtual access to courts. With eCourt version 2, we will have a unified, comprehensive, and intelligent case management system for the entire judiciary, covering cases filed from the first and second level courts and other collegiate courts, including the Supreme Court. Now that we know what the eCourt version 2 is, let us now discuss its key features and functionalities. eCourt version 2 has the following key features covering the pre-filing phase: e-filing, e-payment, and e-raffle. To post-filing phase through electronic service of summons, intelligent case monitoring and tracking, and digitized rolio. First, we have the e-filing. It enables litigants to file court papers online using ICT devices. Second, we have the e-payment. It involves an application designed to provide courts the option to receive fees and payments digitally from litigants, their counsels, and representatives in a safe, secure, real-time, 24/7 basis from anywhere at their convenience. Third, the e-raffle. It allows for the electronic raffling of cases without human intervention using state-of-the-art technology. Fourth, we have the electronic service of summons. Through this, summons are served via electronic means such as email or SMS. Fifth, intelligent case monitoring and tracking. It is the automated tracking of case status, which highlights cases without movements based on incoming documents, outgoing documents, and case incidents. Lastly, we have the digitized Rolio. This feature eliminates the need to transport physical case documents to different courts via land, air, and sea cargo. Through a digitized Rolio, physical case documents will be transformed into a digital format. Visit sc.judiciary.gov.ph for more details.
Second, the utilization of artificial intelligence or AI to strengthen legal research, performance evaluation, anti-corruption programs, public assistance, and speed up the preparation of transcript of stenographic notes. Number 3, the organizational restructuring, the classification of positions, and retooling of skills set that are in line with the judiciary's technological trust. In view of the judiciary's digital transformation, there must be a parallel transformation of its human resources. This will be done through the assistance of the Philippine Judicial Academy. Number 4, the establishment of a centralized planning and management unit to address the issues and challenges regarding limited access to courts, inefficient data management, and other administrative-related concerns. Insofar as strengthening the capacity, ability, and skill sets for the member of the bench is concerned, the successful prejudicature program has been made mandatory for first and second level trial court aspirants. Likewise, an advanced prejudicature program shall also be made a requirement for aspirants to the appellate courts to ensure that the applicants to judicial posts will possess the competence, integrity, probity, and independence that the Constitution requires members of the judiciary. These are but a number of plans and programs that the Supreme Court is undertaking and will undertake for the improvement of the entire Philippine judiciary. With the support and help of every stakeholder, especially you, the members of the media, I have no doubts that these plans for a more effective and responsive judiciary will come into fruition. Thank you for your time.
Thank you very much, Chief. We will now call on the members of the media to ask their questions in the order as it appeared in the chat box. Our first will be Mr. Ray Panaligan of Manila Bulletin.
Good morning. Good morning, everyone.
Good morning, Mr. Ray Panaligan.
Thank you very much po and happy anniversary to the Supreme Court. Chief Justice, ang sabi po kasi nung nag-text sa akin ito, magsalita ako sa ating national language para maintindihan nilang mabuti sa probinsya. Ang tanong po nila, Chief Justice, is, and itinatanong ko na po ito for the past 3 years, bakit po sobra ang delay ng release ng mga decisions and resolutions ng Supreme Court, lalo na sa public? Would you like me to cite an example? Halimbawa po yung More Electric Cooperative, March 9 po na-resolve, May 25 na-release. Yung pong, hindi ko pa po nasulat ito pero maganda po ito Yung pong administrative case na sa letter ni Secretary Duque, na promulgate po ng February 21, May 18 lang na-release. Yung pong pet case, February 16 na promulgate, April 19 na-release. At isa pa po itong Relampagos, January 27, na-release po ng May 6. Nung pong time, sabi ko po kanina, nag-cover ako time pa ni Chief Justice Fred Ruiz Castro. Pagkatapos po ng kanilang en banc, immediately nare-release na po yung ruling ng Supreme Court. Kahit wala pa po yung dissenting or concurring, kasi ang importante po naman yung majority ruling. Thank you po, Chief Justice.
Maraming salamat sa katanungan mo, Ray. Totoo na merong delay sa pagre-release ng actual decision o resolutions. Una, ang dahilan dyan ay ang pandemya. Sapagkat nag-impose ng mga quarantine restrictions, maraming pagkakataon na mga empleyado ng Korte Suprema ay hindi nakakapag-report physically sa court. In fact, ang pagpasok ng mga empleyado sa Korte Suprema ay naaayon sa regulasyon na pinatutupad hinggil sa kwarantina. So may pagkakataon na 25% lamang ng mga empleyado namin ang pwedeng pumasok.
Mozo, no? Wala.
Minsan may panahon na mas marami, depende sa sitwasyon. At ang isa pang bagay na dapat naming maunawaan, ang pag-release ng desisyon ng korte ay dumadaan sa mga administrative yung proseso. Kung ang desisyon ay napagkasunduan ngayong araw na ito pagkatapos ng sesyon, ito ay dadalhin pa sa punente para isulat ng pinal at iimprenta sa isang papel na tinatawag naming Gilbert paper. Pagkatapos itong maimprenta sa Gilbert paper, ito ay iikot sa mga miyembro ng division or ng NBank na kailangang lagdaan ang desisyon na pinal. Dahil sa sitwasyon, wala kaming paraan kundi puntahan ang bawat maestrado sa kanilang tahanan upang lumagda sa desisyon. Sapagkat hindi kami nagkikita-kita na in person dahil nga sa COVID. Matapos siyang maglagdaan ng mga miyembro, yan ay muling rirepasuhin o re-reviewin ng isang proofreader. Sapagkat wala namang perpektong sitwasyon, maaaring magkakaroon ng mga pagkakamali sa pagka-imprenta o pagkasulat ng desisyon. So ayan ay ibabalik muli sa punente para makita niya yung correction na yan. At kung yan nabago at itinama na, ibabalik yan, dadalhin sa opisina ng punong maestrado sapagkat siya ay required to certify the decision. Yan ay riribisahin pa ulit sa tanggapan ng punong maestrado sapagkat bago lumagda ang isang punong maestrado, kailangan siguraduhin niya na ang desisyon ay walang mali at naayon sa napagkasunduan nang ito ay pinag-usapan sa deliberasyon. Pagkatapos niyan ay ibababayan sa clerk of court. Saka pa lamang yan ma-promulgate. Kung yan ay na-promulgate na, yan ay dadalhin pa sa printing office ng Korte Suprema. At doon, iimprentehin yan para may padala sa mga partido na kasama doon sa kasong iyon. At alam naman natin ang proseso, sa malimit na pagkakataon, ang desisyon ng Korte Suprema ay hindi na isilbi ng personal o what we call personal service. Ito ay pinadadaan natin sa sistema ng ating postal system. So maraming bagay kung bakit medyo na-delay ang pag-release ang promulgate ng decision. Subalit, meron na kaming mga tinatalakay na hakbang sa Supreme Court and Bank na ang plano namin ay sa online pa lang, pag napagbotohan ng isang desisyon, ito ay makikita nyo na sa website ng Supreme Court, hindi ang buong desisyon, kundi ang tinatawag naming dispositive portion. So bawat linggo, nagkaroon ng sesyon, either NBank or division. Whatever was voted upon by the division or the NBank, the summary will be published already in the Supreme Court website. So malalaman kaagad ng mga partido kung ano ang kinahinatnan ng kanilang mga kaso. Sabi ko nga, gagamitin namin to the fullest ang teknolohiya upang maipaabot agad sa sino mang interesado sa mga kaso na nabibinbin sa Korte Suprema. Yan po ang aking tugon sa inyong katanungan.
Sir Ray, please unmute.
Maraming salamat po, Chief Justice. Sana po yung mga nag-text sa akin galing probinsya ay naintindihan nila ang sitwasyon kung bakit nadidelay. At sana po, in the coming days, mabilis na po yung pag-release, even the summary, particularly the dispositive portion ng mga decisions. Maraming salamat po.
Gagawin
Ako po
po namin yan.
I think I am entitled to another question, Attorney Brian. Ang itatanong ko po sana, Chief Justice, ano po nang ginagawa na ng Supreme Court to protect lawyers, judges, sa mga series of killings, etc. At saka ano po ang nangyayari na sa judiciary marshal? Ang pinakahuli ko pong nabasa dyan is inapprove na ata ng House. Pero are we expecting na ma-approve po yan in the next immediately, Chief Justice? Thank you po.
Okay, sa una pong katanungan nyo, hinggil sa mga nangyayari sa mga abogado, huwes, na namamatay o pinapatay o tinatakot. Kung matatandaan nyo po, nung pong March 23, 2021, ang Korte Suprema, ang mga maestrado ng Korte Suprema, ay nagkaisa ng magbigay ng talastas or statement of concern. At hinimok namin ang bawat isa na mga naapektuhan nito, maging mga abogado, asosasyon, kasama ang mga tagapagpatupad ng batas, ang pulisya, na mag-submit sila sa Korte Suprema ng mga datos, mga report hinggil sa bagay na ito. At binigyan namin sila ng mahabang panahon. At ito ay sinumiti nila sa tanggapan ng Public Information Office. Natanggap namin ito. At pagkatanggap namin ito ay aking pinadala sa aking mga kasama sa husgado at tinalakay namin ito at napagkasundaan namin ng bagay na ito ay talaga or assign it a committee for evaluation, report, and recommendation. Marami pong mga datos kaming natanggap, subalit kinakailangan po nating himayin ito upang maunawaan namin at saka lamang kami makapagbibigay ng aksyon. We will act on those, the results of those report and recommendation within the jurisdiction of the judiciary. If outside the judiciary's jurisdiction, then we will endorse them or the results to the appropriate entity or institution of government for them to address these issues. Pero ang nasisiguro po ko sa inyo na ang Korte Suprema ay tinatalakay ito. Yung pangalawang katanungan, pakiulit lang po. Judicial Marshal po.
Yung Judiciary Marshal po, Chief Justice.
Kagaya ng sinabi ninyo, as you mentioned earlier, it has passed through the readings in the lower house. And we are optimistic that once this approved bill from the lower house is sent to the Senate or the upper house, the Senate will act on it. Hopefully, before the end of this current Congress, the Judicial Marshal bill will be approved into law. At malaking tulong yan. It will be of great help if the legislative body passes that proposed bill. Because makikita natin kung paano bubuuin ang Judicial Marshal para matugunan nga, ang mga sitwasyon na ang ating mga maestrado at empleyado ng korte ay nalalagay sa sitwasyon ng threat or violence. Maasa kami na ang lehislatura at ang eksekutibo ay ipapasa at lalagdaan agad ang batas na ito. Salamat po.
Thank you very much, Mr. Panaligan. I believe we have several questions from other members of the Justice Beat. Due to limited time, let's proceed, Tiff, just to give chance to everybody to be able to ask their questions. I think next in line is Anjo Alimario from CNN Philippines. Go ahead, Anjo.
Hi Chief, good morning po and also to all the justices present. Happy anniversary po sa Supreme Court. Chief, just want to ask, several lawyers and groups are pushing for amendments to the rules on issuance and service of search warrants. In fact, some of them have already wrote to the Supreme Court and listed several suggestions or proposals to amend the rules on issuances and service of search warrants. May I ask, this of course in light of several activists who were killed when they were served search warrants. Just want to ask, do you see any need to revise the rules on search warrant?
Thank you, Anjo, for that question. In relation to that statement of the court, March 23, 2021, Justice Leonen submit to the court and back a working draft on the revisions intended and specifically address the issue on issuance of arrest warrant and search warrant. We are working on it, and in relation to that, we will be amending the rules on criminal procedure with respect to those provisions. And one of the things that we are now working on is the adoption of the rule on the use of the body worn camera. The proposed rule is to be taken up as soon as we resume session on June 15. And our colleagues have submitted their respective inputs. Hopefully, and we're optimistic that maybe 2 or after 3 deliberations, we will come up with that final version. The court is very clear in our statement that with respect to the issuance of arrest warrant or search warrant, our judges knows their responsibility, that they have to comply with what the Constitution and the rules of court should provide. So we hope that with the issuance of these rules on BWC or body-worn cameras, these issues will be addressed specifically. It's in the works, and by July perhaps we have the final version and we'll approve it for implementation immediately.
Thank you
Sir
very
Brian,
much.
may I be allowed one follow-up?
Anjo, can we go back to you? Let's finish the round first. Okay. So
Thank you.
go ahead, Tiff. Who's next in line?
Yes. The next in line is Ms. Christine Patag of philstar.com.
Hello, good morning, Chief. Good morning po, Justices. And happy anniversary po to the Supreme Court. This is Christine Patak from philstar.com. Chief, my question is on the writ po. Will the SC also review the rules on the writ of amparo and habeas data? This was asked din po by the several groups that wrote to SC regarding the March 2021 statement that you issued po. And also, is there an update po on the writ of kalayaan which was discussed in Almonte versus People? And the petition of the political prisoners asking for humanitarian release. Thank you.
Thank you, Christine, for that question. First, on the revisions of the writ of kalikasan and writ of amparo, I have, as early as I assume office, I requested the Office of the Court Attorneys to do their research. Specifically, those materials that may be available from other jurisdictions, because I understand that the writ of kalikasan in particular was adopted as early as 2010, and a number of changes have happened concerning protection of environment. We are awaiting the report of the Office of the Court of Attorneys for the materials that may be gathered. The same with the writ of amparo. So we are doing our continuous effort to revise these specific rules. It's just that we have to gather more materials to guide us in the revisions. But it is one of the priorities of the court for revision. On the writ of the kalayaan, this is an innovation which will obviously require a thorough study. You will note that writing the rules of procedure takes time, because we have to consider a lot of factors before arriving that in those or adopting those rules, because we have to make sure that we do not deviate from what the Constitution requires or allow us to do. Consistent that while we may be allowed to adopt rules concerning the protection of constitutional rights, we are also mandated that we must adopt rules within the parameters of our jurisdiction.
Thank you very much, Christine. Our next question will be coming from Ms. Tech Torres Tupas.
Good morning po, Chief Justice. Good morning, Justices. And happy anniversary po. Sir, what is there any update on the procurement of vaccines for the judiciary? How is our coordination po with the IATF and the DOH?
Thank you, Ted, for that question. As I mentioned to you earlier, even before I assumed office as Chief Justice, the indefatigable Senior Associate Justice Estela Perlas Pernas had worked so hard, not only in upgrading our classification for purposes of priority listing, but she had also done her part in making sure that we get an allocation. I know for a fact that we have scheduled vaccinations, and we're doing it here in the Supreme Court facilities already. We have requested the local government unit of Manila initially to assist us in this vaccination activity. But we were told by the COVID task force and vaccination that we can do it ourselves, and we will be able to train our own medical personnel, I think, to do the vaccination. I don't know. I cannot really cite the projected completion of the vaccination, but I was told by Justice Bernabe this morning that for this week, there is a schedule for 400 people to get vaccinated. We are focused on that. We have created a task force to supervise and ensure that the vaccination takes its place in accordance with the schedule and on the number of the vaccines available for the judiciary. Also, through Court Administrator Maidas, who is the head of the task force on vaccination, we have already requested also the judges and court employees of the different regions in the country to apply online if provided in the LGU unit to receive the vaccines. I received a report from the RTC judge in Bacolod that all the judges there, court personnel, and even police officers and lawyers who appear before their courts have been vaccinated. We are, as I said, we are focusing on it because it is my view that the court can become fully operational, meaning people can report in person, perhaps less than 100%, only when they have been vaccinated completely, meaning the first and second jab is completed. Thank you, Ted.
Thank you, Tej. Before we proceed, we would just like to remind those who just joined us to send a message to the chat box of this Zoom meeting should you wish to ask a question. Okay, let's move on. Our next question will be coming from Attorney Mike Navalio of ABS-CBN. Go ahead, Mike.
Good morning, Chief Justice. Good morning, Justices. I would like to touch on the point made by Chief Justice Gesmundo about improving the disposition of cases. I understand that there are rules that will apply prospectively, but what about pending cases? Because we've come across a recent case, a single mother who was imprisoned, detained actually for 17 years, and she was acquitted and released recently. So how would you try to address pending cases that have languished for 17 years, only to end up in an acquittal? Are there steps to ensure that the provisions in the Constitution on disposition of cases within a certain period are actually met?
Thank you, Mike, for your question. As I said earlier, the court agreed that we adopt a case decongestion program. specifically to address the so-called age cases. And we have agreed that in the next 24 months, that will be a priority of the Supreme Court along with the incoming cases. Now, it is a sad note that one who is in prison for the last 17 years only to be acquitted thereafter. So what we have planned to do, as I mentioned earlier, is that we would publish early as we can the results of the voting in a case. So if a criminal case is decided by the court, acquitting or convicting the accused, it will be immediately posted in the Supreme Court website. Further to that, when we adopt technology, it is our vision that the moment that we have a decision acquitting an accused, we can code the dispositive portion, electronically transmit it already to the facilities where they are being detained, informing them that there was a decision of the court acquitting the accused. Now, how do we protect that? I have already suggested also that we adopt some the technology, something like the QR coding, that the decisions, resolutions of the court may be authenticated online. So once we are able to do that, if we transmit a decision to the National Bureau with Prison, with the facilities of technology, they can authenticate already the resolution or the decision of the court, acquitting the specific detainee. And on the basis of that, they can process the release of the prisoner. This will be made possible, as I said again, with the technology. It is true that there were cases languishing in the docket for quite a number of years, but we are committed that we dispose of all of them in the next 24 months. To avoid a repeat of that situation, each and every one of the members of the court, through its self-imposed discipline, but ultimately will be provided in the internal rules of the court that we decide cases as required and mandated under the Constitution. That is our commitment.
Thank you, Attorney Mike. We will now proceed with Rappler's Lian Buwan. Go ahead, Lian.
Your Honors, Chief, good afternoon po. Happy anniversary. I just like to manifest that I have a second question if time permits later on. But my first question, Chief, is the unbank mooted the ICC petition, and the petition questioning the unilateral abrogation of the VFA is still pending. Both were filed by senators wanting to question just where does presidential discretion end. And I understand that there would be a guideline in the ICC decision, but some people are asking the matter of the issue is live. There's still a drug war. People are still being killed. So they're asking, shouldn't the Supreme Court answer these questions? Because it's a question that the political branch is asking about the other political branch, about a very powerful president who has the tendency to do things unilaterally.
Okay, so you're interested on the details of the ruling of the court in ICC case involving Pangilinan versus Cayetano.
Yes po, if you may indulge us.
I will deviate with the procedure because I will allow the ponente, Justice Marvick Leonen, to give you a brief answer to your question. Justice Marvick, do me a favor, please.
With pleasure, Chief, and on behalf of the bank. First, I'd like to clarify, Lian, the Pangilinan versus Executive Secretary did not deal with the drug war. It dealt with a very specific legal issue, and the specific legal issue was the constitutionality of the withdrawal of the consent of our adherence to the International Criminal Court, or the Rome Statute. So the court was focused on that, and with respect to the drug war and the impact of the case on the drug war, I think you have to wait for other cases that may be pending in the lower court or in the Supreme Court. I think there is one in the Supreme Court entitled Almonte versus Executive Secretary. The court actually not really mooted, but there were several petitions. The petition filed by the Senate was called by the Supreme Court as premature, in the sense that the Senate had a pending resolution that proposed its own action on the withdrawal, but it did not table it for discussion. So therefore, as on behalf of the Senate petitioners, the court held that it was premature. On the other hand, with respect to the other petitioners, it was moot because it was already delivered and acted upon by the International Criminal Court. The notice was already delivered. There was already an action by the criminal court. However, the court said that the power of the president to withdraw is not absolute. The president can withdraw. However, if the Senate has concurrence which is conditional, such as in the subsequent concurrences of the Senate on many treaties, then the president cannot just withdraw. The second condition is if the president was given negotiating authority, such as in tariffs, treaties, etc., then the president cannot negotiating authority to negotiate a treaty. The head of state may not just simply withdraw because there is already action on the part of the legislature. And finally, when the legislature implements a treaty via a new statute, then they cannot just withdraw. In the case of the ICC, the law came first before the treaty. And I think in the decision, it is very clear that some provisions in the treaty may have amended the actual statute that was already produced. Let me add just a statement that the court tries to avoid getting into political issues such as, for example, the drug war in general. We would rather attend to specific facts, raising specific issues in the proper way through the proper petitions, the right way, the right time, and the right place. Thank you. Thank you, Chief.
Thank you, Justice Marvick. Thank you, Lian, for your question.
Thank you, Lian. Let's now proceed to UNTV's Dante Amento. Go ahead, Dante.
Yes po, good noon, Justices, Chief Alex. My question was actually answered by CJ on the guidelines for the use of body camera. Babati na lang po ako. Happy 120th anniversary po, Supreme Court. Salamat po.
Maraming salamat, Dante.
Thank you very much, Sir Dante. Our next will be Mr. Benjamin Pulta of PNA.
Good afternoon, sir. Good afternoon, sir. I have a very short question, kaya baka pwedeng mag-second question if Attorney Brian would allow. But my short question is, has any one of the justices been vaccinated for COVID? Just by a show of hands, or do you know a number na kung kailan?
Well, Benji,
Yes, sir.
all the members of the court have been completely vaccinated. Because we improved on as we requested the task force on the vaccination, we requested that we be upgraded to A4 category. So we were provided with vaccines. And I think all of us have completed the second jab.
Sir, my question being short, can I ask a second question now or later na?
We have, you're the first round, Ben. Can we just do the rounds and go back to, we'll go back to you. So we'll be allowing a second round. So who's next, Tiff?
For the second round, our first will be Attorney Mike Navalio of ABS-CBN. Hold on.
Ask about what your views are about exercising the rulemaking function of the Supreme Court. I know that you've been involved in crafting several rules to implement or to, in fact, to enhance the speedy disposition of cases. But with respect to protection of certain rights, like for instance, the mayor of Calbayog, who was killed in relation to that narco politician list, and the recent decision of the CA, which declared that in that particular case, an actual case should have been filed by the authorities. To what extent will you go? Because I note that the previous justice, Chief Justice Sereno, actually made a statement on that, and I think many of us know what happened after that. To what extent will you exercise that rulemaking function towards protection of certain rights of the public?
Of course, the court is mandated under the Constitution to promulgate rules concerning the protection of constitutional rights. My predecessors have adopted that. And the best example of that is the writ of amparo. It was nowhere in our law, it was nowhere in our previous constitution. But to give life to that constitutional mandate given to the Supreme Court under the 87th Constitution, the Supreme Court will adopt rules as the exigencies will require in order that these constitutionally guaranteed rights are fully protected. Some may question the authority of the court to promulgate those rules. But again, under the mantle of the constitutional protection that we can adopt rules concerning the protection of constitutional rights, the Supreme Court will promulgate those rules when it finds it necessary, only that it must be within the parameters of the Constitution. Things change over time. And as I said earlier, the court must be able to adapt to these changing times. So when the circumstances should warrant for the court to adopt those, I'm sure my colleagues will not hesitate to adopt those rules. Thank you, Mike.
Thank you, Mike. I think we missed out on Marlon. Marlon Ramos for the first round. Marlon Ramos from Philippine Daily Inquirer. Marlon?
Chief, good morning po, Chief.
Good morning again.
Morning. Chief, tatanong ko lang, how's the drug war review? Previously, the court had ordered the OSG and the PNP to submit records of all anti-drug operations that resulted in the deaths of drug suspects. Kamusta po yung compliance ng OSG regarding this?
Medyo Tony Brian, hindi ko
Marlon, medyo malabo yung yung feed. Can you repeat your question?
Sorry. Chief, previously po the court had ordered the OSG and the PNP to submit the records on drug war related deaths, these anti-drug operations that resulted in the deaths of drug personalities. Yung compliance po ng OSG, kumusta na po?
That's in the Almora case. A number of documents, or even I think in CD format, were submitted by the OSG as directed by the court. The ponente is working on the case already. So, depending on the submissions he will present to the court in bank for deliberation, that's the time we will see that his assessment of those documents presented by the Office of the Solicitor General.
So the OSG has complied po with the order of, kasi ang order po all records.
I think they did comply. In fact, there were, if I recall it right, even the time that I think it was Justice Carpio who directed the OSG to comply. And I think they did comply.
Thank you po, Chief.
Our next for the second round will be Mr. Benjamin Pulta.
Yeah, hi again, sir. Sir, my question is in connection dun sa ruling. I forgot the case, but in May there was this decision on annulments, which said that the psychological incapacity need not be a medical condition but is a legal condition which may be proved. I think it was written by Justice Leonen. Tanong ko lang, sir, kasi we haven't gotten a copy of that full decision. Curiosity, had the annulment been granted to the parties or to the woman? Kasi apparently the man was a drug addict.
Well, that's the case of Tan Andal, the recent ponencia. Yes, we granted the annulment petition. We reversed the ruling of the Court of Appeals denying it. And it's quite lengthy to discuss because these are new judicial doctrines that was adopted by the court in resolving the issue on annulment of marriage based on psychological capacity. But yes, we granted the petition. We reversed the Court of Appeals in that ruling.
Thank you, sir.
Thank you. Our next will be Ms. Lian Buwan of Rappler. Go ahead, Lian.
Related po sa tanong ni Kuya Marlon, Chief, sa Almora. Just by the order of the questions in the oral arguments, in 2017, we gather it was Justice Carpio who was member in charge of that petition, and Justice De Los Santos was appointed Vice Carpio. Did he inherit the petitions, and seeing that Justice Edsa will be retiring at the end of the month, what is the future for those petitions, seeing that they have been pending for more than 4 years and the documents were submitted more than a year ago by the OSG and the PNP?
Well, yeah, it was submitted during the time of Justice Carpio. Justice Edsa inherited the case as a rule with the Supreme Court. I do not want to preempt Justice Edsa on his recommendation before his retirement. But I'm sure that Justice Edsa do his best that it be submitted before his retirement.
But Chief, all those documents have been already fully evaluated. All the documents submitted have been fully assessed.
Unfortunately, Lian, I cannot supervise how Justice Edsa does his work in a specific case. We merely rely the moment a draft ponensya is circulated. And what his analysis will be is too early for me to say until the draft ponensya or the report and recommendation is distributed to each member of the court.
Thank you, Chief.
Hopefully,
Thank you,
Justice Edsa will be able to write his ponensya before he retires.
Thanks po.
Thank you, Lian.
Okay, Tiff. I think we have the last two questions, one each. The penultimate question will be coming from Anjo, and then after that, the last question will be from Marlon Ramos. So go ahead, Anjo.
Hi, Chief. Sir, just want to get an update on the. I think the court ordered the court administrator to investigate the red tagging of Mandaluyong Judge Kisumbing. Whatever happened to that, sir?
Court Midas, I understand that the judge was given some kind of security measures to be protected. We have yet to receive a report from the PNP, I think, on who is responsible for putting up those tarpaulins along EDSA. We are coordinating with the police on these issues. In fact, when we had a courtesy call from the former PNP chief, there are a number of matters that we took up with them. And hopefully, when we meet the new chief PNP also, who requested for a courtesy call, we can be updated on those things. But one thing sure, we address the security concern of the judge involved.
Thank you very much, Anjo. Our next question will actually be coming from Mr. Bert Mozo of DWIZ. Chief, he sent in the questions lang po. I will read them.
Please
The
do
first, okay po. The first question is, how the CJ addresses cases beyond 24 months pending before the SC na wala pa pong decision. And then the second question po, Sir, facing the power crisis by the next year, paano po mai-implement ang video conferencing sa mga remote area? Ano po assistance sa mga courthouses, judges who doesn't have good internet connection and facing this power crisis? Thank you po.
Okay, in the first questions, I have responded to that we're committed to abide what the Constitution says for cases filed April 5, 2021. As regards those cases filed earlier than April 5, 2021, we are doing the case docket decongestion, and we are committed to decide all those cases in the next 24 months. On the issue of power crisis that may affect the video conferencing of trial court judges, first, we are not sure, and we have no data yet on the extent of power outages. At the moment, we just see what is reported in the newspaper and in the broadcast media on the looming power crisis. We'll address those issues when it really comes to us now. On the issue of being able to conduct video conferencing because of inadequate or unreliable internet service. We had a dialogue last week with the Judiciary Reform Initiative, a group of business people who have expressed support to the judiciary. And we are grateful for that. And one of the matters that we specifically raised to them is to be able to make representations with the telco that broadband facilities, especially for court video conferencing, should be addressed. And they immediately responded, and somebody called me up already from the DICT, looking at the possibility of the ICT to provide internet services to the judiciary. I emphasize the fact that the Philippines is composed of 7,101 islands. And at this point in time, not all these islands either power or internet are connected. So, but we will always try to address. In fact, when the court, and I assume on April 5, the first step that I made was to have a town meeting with all the trial court judges, together with my colleagues. As you have seen now, the meeting should have been meet the press with CJ. But I invited all of the members of the court and bank to be present. Because when I make a commitment, they should be made aware. So that we work collectively. This is a collegial court. So if those issues should crop up, for sure the court and bank will address those issues.
Thank you very much, Chief. Our last question will be coming from Marlon Ramos of Philippine Daily Inquirer. Go ahead, Marlon.
Chief, tanong ko lang po, since you already mentioned the issue on the clogged dockets of the court, in recent years, we have seen individuals who, instead of filing cases, they seek redress in social media. This eventually gave rise to the popularity of public affairs programs of TV stations. Isa na po dito, syempre, yung sa Tulfo Brothers, and this actually paved the way for the rise of what they call quote-unquote Tulfo brand of justice, which is not only swift but also free. Kasi kung yung mga ordinaryong mamayan, magpa-file sila, magbabayad sila ng abogado, they will also have to pay for the docket fees and other legal fees. Ito po, libre. Do you think this kind of phenomenon is just shows the deficiencies in our court system? Kaya maraming tao outside of the judicial process na humihingi ng justisya.
Thank you, Marlon, for that question. With due apologies, I have not watched those programs. But as I said earlier, things have changed over time. People now have seen another platform by which they can air their grievances. They find it convenient to, go to these public service programs. But I would say that, and I will look at this positively in a way that this might be in the form of alternative dispute resolution. If people want to access those, and for as long as that their rights are not trampled, I guess we cannot stop people, especially in our culture. I mean, without demeaning, we are prone to litigations, and we cannot possibly settle things amicably. But the situation there is no different from what is provided by law under the local government code. There is such thing as a katarungan parang pambarangay, and there is this lupong taga pamayapa. But apparently, they would rather go to these public service programs because they feel that there's an instant relief that they can get on by resorting to that. But the point at the end of the day is that they might agree and arrive at a settlement, but the question later is, how do you enforce that settlement? Do you go back to the radio program and complain again? and say that, you know, the guy who committed during your discussion reneged on that commitment. Unlike when they resort to judicial processes. You see, admittedly, judicial processes are quite long, but this is what is required under the Constitution. We have to have procedural rules if you go to court so that justice can be administered in an orderly manner. If they are able to get the relief using that platform provided by technology, I don't see anything wrong about that. But my concern is, you know, I asked some questions about the platform being adapted, and they told me that, you know, there might be issues on the dignity of a person, something like that. In the judicial process, we avoid the, you know, the disrespect for other people's right. Again, with the essence of due process. I will not say that it is improper or there is a lack of judicial process. There are judicial processes, but some people, I think, are too impatient that they want instant relief immediately. And they thought that using this platform will provide the avenue for them to be able to address their grievance immediately. At the end of the day, when you look at this, I was told that these are sometimes purely personal problems that are not legal in nature and therefore will not require judicial intervention. Most of these are interpersonal relations that, you know, will end up only in court when there is a legal issue involved. But looking at it positively, I will call it as an alternative mode of dispute resolution. If they're happy and contented with the results, then let's respect their choice.
All right. That's the last question, Chief Justice. There's a request for a group picture from our friends from media.
Sure.
May request the participants of this Zoom meeting to turn on their videos for a group picture. Tiff?
We'll fix the tiles lang po. Ready? 1, 2, 3.
Before concluding and adjourning, I'd like to thank my colleagues for joining me on this special occasion of the Supreme Court. I'd also like to thank the media for spending time with us on this historical day for the court. We look forward for your support, and the court is committed to do its task in accordance with our mandate under the Constitution. Thank you very much and stay safe, everyone.
Thank you,
Thank you
Chief.
very much, Chief
Thank you
Justice.
po.
Thank you very much, members
you
of the
po.
media.
Thank you po.
You may now press the leave button and have a safe and